The Kashef versus BNP Paribas case is about a company's greed.
What happens when a bank funds a genocidal dictator?
It's not just the people with the Kalashnikovs and the bombs. It's the people that are giving them money. And that is really the problem. And that's why we did the case.
Beginning in the mid-90s, the U.S. administration became very alarmed at the systemic human rights abuses committed by the government of Sudan against its own population. In particular, at the time, there was a civil war. The south of the country, which was predominantly Christian and Black African, was fighting for its independence from an authoritarian Islamist, really Arab supremacist ideology that had gripped the capital. The government engaged in mass killings, starvation, religious persecution, and over time, the genocide escalated, despite the fact that the U.S. had imposed what should have been crippling economic sanctions.
This is a case about bodies being burned, entire crops and villages being leveled, military weapons being turned on civilians, all funded by a bank who didn't care it was happening.
Sanctions were imposed in 1997. By the time 2005 rolled around, it had been nearly a decade. And instead of defunding the government of Sudan's war machine, the government of Sudan was selling its oil in US dollars. It was awash in cash. It had developed its own domestic arms industry. It was importing new weapons and aircraft. How was it doing it? How was it getting all the money? Well, that was a central mystery that the US government tried to understand. And it investigated that. And it discovered that one bank, a French bank, BNP Paribas, was single-handedly partnering with the government of Sudan as its de facto central bank to launder essentially all of its foreign currency reserves, all of that oil money, all of that laundered through New York, and it went to feed the killing machine in Darfur.
They would block out the names of the entities that were involved in transactions so that the filter known as OFAC here in the United States wouldn't pick it up and block the transaction.
The Department of Justice fined them billions of dollars for it. On the heels of that, there was then a civil lawsuit brought by Sudanese refugees, 23,000 Sudanese refugees. And that case then persisted for about 10 years.
At that point, our co-counsel Lee Boyd, who had originated the case, was reaching out, speaking with other human rights litigators around the country about taking the case forward.
We knew that this was going to be a fraught undertaking, and we had a lousy 8 weeks to put together a case that took some 10 years to develop.
And finally, there was a trial for 3 of the 23,000.
What had been teed up was conflict of laws. Was the case going to be governed by New York tort law or by Swiss tort law? And it was right after we joined that Judge Nathan decided Swiss tort law would govern. We had to become experts in Swiss tort law.
Perhaps one of the most telling moments of the trial was when an executive from France was flown over and literally answered a question saying, "We knew at the time we were involved in banking services with the government of Sudan that they were engaged in genocide."
At the end of the day, aiding and abetting liability is not that dissimilar in different legal systems. There are a few nuances, but by and large, if someone knowingly contributes to another's unlawful act, they're liable.
For 3 individual plaintiffs among the 23,000, there was a verdict of almost $21 million.
There's always been an element of the bank being too big to be held liable here. And it's sending a message that no one is too big to be liable. The case meant something to us almost spiritually, as about using the law, the courts, to bring justice, to do what we all aspire to do as lawyers.
We have a huge responsibility to lead the fight for justice.